Welcome back to the Politics and Media Show. The government's new Justice and Security Bill is having a bit of a rough ride in the House of Lords. Although their lordships rejected an amendment that would have prevented further use of secret courts, they did vote to limit the role of the Secretary of State in proceedings. So where does this leave us? Is it true that innocent defendants will be unable to get justice in the courts because classified evidence against the state cannot be presented in open trial? And if this is true, is there any alternative to secret trials? Joining me in the studio is David Anderson QC, the independent reviewer of terrorism legislation, Robert Buckland, Conservative MP for South Swindon, and Anna Thomas from the UK Council of Reprieve. Welcome to the programme, everybody. David, so do you welcome what seems to be happening in the House of Lords? Do you think there are sensible amendments to the bill?
Well, I'm glad the bill had a rough ride in the House of Lords because I think there were things that were quite badly wrong with it. In particular, I think the bill gave the Secretary of State far too much control over how the courts went about their business. And I'm very glad that the House of Lords, by quite decisive majorities, corrected that. However, I do think there is a point to this bill, and I do think we have a really difficult problem with evidence that is secret on national security grounds, plainly can't be given in open court, because if you give it, then you might reveal the existence of a human intelligence source, you might reveal the existence of foreign intelligence, of a particular intelligence gathering technique. I don't think in any country in the world would evidence of that kind be given in public. The question is really, which of the second best solutions do you go for to enable the case to be heard as fairly as possible? And in my view, the idea of a closed material procedure, which is at the centre of the bill, part 2 of the bill, although I would hope that it will need to be used only in very rare cases, actually in those cases is the best way of obtaining a fair result, in which all the evidence can be heard by the court, as much of it as possible in open, and a full judgment given, as much as possible of which everyone will be able to read.
Anna, how do you think the thing's going through the Lords? Do you welcome the changes? Do you think there should have been more?
There certainly should have been more. It is, to some extent, a good sign that the bill, as drafted, got such a rollicking last week. But it remains the case that at the moment there's no reason to change the existing PII system, which has worked so well, and so we don't want to get embroiled in the minutiae of amendments to the bill without addressing the fundamental question first about whether or not the government has demonstrated a real need to change the common law system.
And your view is that it hasn't demonstrated that need?
That's right. We have many assertions that it's needed in civil litigation to protect national security matters and for fairness, but I can think we haven't been given any single example, any single case which couldn't be tried fairly under the existing common law system.
Robert, is that your view, that it's an unnecessary piece of legislation in some ways?
No, I think sadly it is necessary, and I mean sadly because all of us in this studio believe in open justice, and we're looking for the most acceptable second best option, as David has said. I think that we've come a long way from the green paper that originally outlined these proposals. The government listened to the sharp criticisms that were made then. They've narrowed down the ambit of this proposal quite dramatically, and we've seen with the vigorous debate in the Lords, again, further proposals and amendments that have been made to the bill that I know the government is considering very carefully. I think what will emerge eventually will be a piece of legislation that balances the interests of individuals who are within the system with the interests of the wider community and our national security interest, which I'm afraid is an important counterbalance when it comes to cases such as the ones that these procedures are designed to deal with.
We're losing something very fundamental, though, aren't we? Here, I mean, the ability of a defendant to have the evidence placed in front of them in an open court. This is something which it's not as if it's a tangential aspect of the legal system.
Well, I don't pretend it's tangential, but to suggest that this is new is wrong. The Special Immigration Appeals Commission, or SIAC, has been operating closed material proceedings for a number of years. In fact, the Abu Qatada case dealt with by SIAC was an application of those principles, and nobody's suggesting that what happened in that case was unjust or unfair, however one may find the outcome controversial. I think the important point to make is that these proceedings, this type of proceedings, must be used in only a very few cases. And the idea that this should spread like wildfire to become a general principle of the legal system is something which not only should be resisted, but which I think it is protected in these particular provisions.
David, are you worried about the mission creep aspect of it? I mean, you've said that it should only be in a limited number of cases, but, you know, once something like this gets out of the bag and starts roaming around, it's hard to put it back in, isn't it?
Well, that's why I think it's very important that the judges be trusted only to use this procedure when there is no other way of trying the case fairly. And I was delighted that the House of Lords amended the bill so that in its current form, that's what it provides. But I still think there will be cases in which that is the only fair way of trying the case. I mean, your readers might, or your viewers might remember the case of Maya Evans, for example, who was the lady who challenged the practice of the British Army of handing people over to the Afghan authorities in Afghanistan. Now, she agreed to there being a closed procedure in that case, and some of the evidence was so sensitive about how the British Army operates in Afghanistan that it couldn't be heard in open court. But the point about a closed material procedure is everything is read by the judge, and everything is read by an advocate instructed on behalf of the person who brought the case, the special advocate. So even if that person isn't able to see all the material, the advocate instructed on their behalf could. And the result of that case was that the court said that in some respects the British policy of handing people over to Afghanistan was not acceptable and had to stop. So you mentioned, I think, the Abu Qatada case. It's another example of a case where a closed material procedure enabled justice to be done on the basis of all the evidence. And the trouble with PII, and Anna mentions PII, which public interest immunity, in its day, a very controversial doctrine and not one that civil liberties organisations always welcomed. But the way PII works is a wonderfully gentlemanly sort of English thing, whereby if evidence is too secret to be aired in public, then both sides simply proceed on the basis that it's not there. You pretend the case is about something else. Now, that might well be possible in a case where the PII claim relates to only part of the evidence, because it's still possible to have a fair trial in open in relation to all the rest of the stuff, and that certainly is a fair solution. The difficulty comes when you've got some of these cases of the sort that have just started to be brought in the last few years about complicity in torture, allegations of helping the Americans with extraordinary rendition, allegations possibly of complicity in drone strikes, these sorts of case, where really the whole subject matter of the case is secret and couldn't easily be aired in open court. And as one judge put it when he decided the AHK case earlier this year, there are some of these cases, he was talking about exclusion and naturalisation cases, but the same principle applies. There are some cases in which the only alternative to a closed material procedure is that the claimant's case is struck out, because there's no way it could fairly be tried. And I think people who oppose CMP have to be a little careful what they wish for. And I was over in America in June, looking at the way they do civil litigation there. And if people begin a case of the sort that I mentioned, the Obama White House comes in, it claims state secrets privilege, says you're not allowed to litigate on this issue because it's secret and it couldn't be done in open court. And the result is that the case is struck out. And these cases are routinely struck out, cases brought by the American Civil Liberties Union or by Human Rights Watch or by others. And I feel very strongly that that is not a road we want to go down, because it is essential that courts have the tools that they need to get to the bottom of these issues, even if the price you will occasionally have to pay is that the person who brought the case can't himself or herself see all the details of the evidence against him.
Anna, do you think there's a problem here actually in the way in which the debate is normally framed? Because the point that David's made is a valuable one. It's one that many people will want to see properly discussed, but it's not the framework within which the debate about this legislation is currently framed. The way in which it's currently framed is that there are very bad people who are terrorists doing absolutely terrible things, and in order to prosecute them properly, we have to have secret trials. The aspect of which is missing from there is what you do about state behaviour when somebody is trying to get redress against the state, which is the question that David's raised. So we're having a slightly skewed debate, aren't we?
Yes, and we believe that the bill, as drafted, even as gone through the Lords, will effectively put ministers beyond the law and impact significantly on the state accountability and the right of an individual to challenge state complicity in torture, rendition and all these things. The trouble with a closed material procedure is that the evidence will not get heard or challenged by one party at all. David rightly refers to the fact that there are special advocates, but the special advocates at the moment are prohibited from speaking or the bill is drafted, to the claimant. So they cannot do their job. They cannot even take instructions on the gist of the evidence that's being heard. So closed material proceedings will not then resolve anything. Nobody's name will be cleared, no issues will be resolved, the claimant won't know what's happened, and nor will the general public. This isn't the way, in my view, to achieve the balance between open justice and, of course, protecting national security interests on the other hand.
Robert, I mean, the question that David raises there, does that sit uneasily with you, the fact that the state may not be in these cases above the law, but it is certainly subject to a different law than other individuals might be?
Well, first of all, let's not forget that we're dealing with civil cases. This is not about the criminal process at all. So this isn't about the liberty of the individual vis-à-vis the state. This is about the liability or otherwise of the state for actions, omissions, or some form of behaviour that could incur compensation for the claimant. That's what this is all about. And the problem at the moment is that the state, the British state, is over a barrel. If there is to be full disclosure in the conventional way, very often that information can be of such an important and sensitive nature that the British state, quite rightly, for national security reasons, does not wish to disclose it. And it's not just in the interests of our country, but also other countries with whom we may share information. And the danger that we face at the moment is that with the current regime, other countries will be more reluctant to share information of a sensitive nature with us. Now, that's bad for our security. It's bad for the security of the people of this country. And it's bad generally, I think, for the stability of international relations. So this isn't just a question of individuals against the state. It's a question of wider national interests coming into play here. Now, my belief is that we are looking at a very few cases indeed, but the number of the type of cases that is coming forward is increasing, and therefore the need for this bill has been and is being demonstrated. It does, in my opinion, strike the right balance. However, I would say this. I think the debate about the extent of the judge's discretion is really the key debate in all of this. And if there can be found a proper wording that allows judges to have an element of discretion when deciding whether or not to use closed material proceedings, then that should be done. But I want to emphasise the fact that at no point is this some power grab by ministers who want CMPs to be used as a first option. It is very much a last option, a last resort, when other procedures such as PII cannot, as David has described, cannot actually deal with the particular case in question.
Well, I think if that's so, ministers have to learn to trust the judges a bit more than they did, because in the bill that went to the House of Lords, it seems to me there were two things glaringly wrong with it. And the first was that the only person who could make an application for a closed material procedure was the minister. So, despite the fact that the individual might have had their own reasons for wanting the case to be heard in closed procedure, as our judges have several times acknowledged, they had no opportunity to make that request. And the House of Lords put that right. The other question, as Robert says, relates to judicial discretion. And the other thing wrong with the bill is that although it appeared to give the judge the last word in terms of deciding whether there should be a closed material procedure or not, the reality was that that word was dictated to him by the Secretary of State. Because if the Secretary of State certified that there was material in the case, release of which in public could cause damage to national security, the judge was obliged to go down the closed material procedure route rather than any of the other routes that might be available to them. Now, I don't buy into the idea this was some sinister government plot and that the government is trying to bury its secrets or anything like this. I think it has much more to do with an unwillingness to trust the judges, perhaps as fully as they might, because we do have very independent judges in this country. You've only got to look at the way they criticised MI5, for example, in the Court of Appeal in the Binyan Mohammed case. I think that criticism really stung. But the reason we have a parliament, as distinct from government, is to put these things right. And I'm absolutely delighted that the House of Lords has done so. I hope the House of Commons follows suit in due course.
And Robert was raising an issue about the civil litigation and whatnot. Is part of this, do you think, on the part of the government, driven by the fact that there's large financial payouts being made?
Large financial
payouts being made?
Well, certainly it appears that this bill was introduced after the Binyan Mohammed litigation, although it appears that it was introduced as a result of that the government was plainly embarrassed in that case, and we would suggest it was the embarrassment of being exposed in the way that they were exposed, because the security services were criticised heavily by the Court of Appeal in that case, that has driven the bill forward. It is right that that closed material proceedings started out in special immigration tribunals, and they then very quickly moved to control order proceedings as well. So there has been mission creep, and I would say that introducing them now into civil litigation was further mission creep. Who knows what may happen next?
Are you worried about that, Robert? Because I mean, you've said all along, you know, it's only a small number of cases, but I mean, Anna does seem to suggesting that this process is migrating from one area of law to another.
Well, I think it's a legitimate point to make. However, I think the criterion here relating to national security is an important point to remember. Now, there's a big argument about whether national security should be defined. Now, when you look at national security exemptions in the Convention on Human Rights, for example, you know, there isn't a hard and fast definition of what it means. But when you hear ministers and when you hear the government saying that their expectation is that it will be only used in a few cases, and that is on the record in Parliament, then that is something that we have to hold the government to and make them accountable for, should we see the sort of mission creep that Anna quite rightly worries about. I mean, coming back to it, I fundamentally here, the question should be asked, why not have these matters resolved and litigated upon to their full extent? Anna's mentioned the settlement in the Binyan Mohammed case. We'll never know precisely what the merits or otherwise of that case were because of the way in which it was dealt with. I'd much rather see cases like that resolved by judges making decisions and either holding the government to account and finding them liable or not. Now, I think these proposals will allow that to happen, so that we will see decisions being made by independent judges and we will see the merits of these claims.
Much store has been put on the Binyan Mohammed litigation. It falls to me to point out that the government chose to settle that claim at a very early stage of proceedings, so before the court had any opportunity to consider whether or not public interest immunity or any of the other procedural mechanisms available could have enabled that case to be resolved fairly in the absence of a CMP.
I think the reality of that case was it was the type of case that David's described, where the very nature of the case was dominated by the national security issue. I think it must have been clear to those involved that existing provisions such as PII just wouldn't be an adequate way of dealing with the case.
Nor did the government make an application for strikeout, which they could have done if they had really felt that the case could not be heard fairly.
Well, I think it's rather to the government's credit that they don't apply to strike out these cases. But I think the message we're beginning to get from the courts is that there will be some cases in which, if no closed material procedure is available, a strikeout is going to be the only alternative. And I quite agree with both the other speakers that it would be an unsatisfactory alternative. Because if the intelligence services did everything wrong, then they deserve to be told so in no uncertain terms, in an open judgment, which is what will happen even after a closed material procedure, and the victims of their conduct deserve to be compensated. But if, on the other hand, they did everything right, they deserve to know that as well. And the problem with a situation in which there is no fair way to try the case and you end up settling with it, not just a financial problem, it's a reputational problem, and it's a problem of uncertainty. because no one at the end of the day knows where they stand.
And what would be an alternative, in your view, to this bill? You don't like the bill, but what would be an alternative way of dealing with this matter?
The alternatives are those that exist at the moment. So we've discussed public interest immunity, the exclusionary rule of public interest immunity, which enables a judge to weigh up whether or not a particular document should be disclosed or not, whether or not it's weighing the interests of open justice and national security very, very, very in detail in the particular case. There are anonymity orders, there's redaction, there are in-camera hearings, there are a whole ream of procedural mechanisms available to the court to weigh up these competing interests and ensure that both justice is done and national security interests are protected, as they have done successfully for many years.
And David, and you don't buy that. There aren't the tools there at the moment.
I don't think you can escape the reality of litigation in this area, which is that there will be some cases in which it is simply impossible to reconcile two very important principles. One is the principle that as a party to litigation, you should see all the evidence in the case and you should have an opportunity to challenge it. The other principle is that justice should be open in a public court with everything on the public record. Where you're dealing with the sort of evidence that might compromise, for example, the identity of a human informer, you simply cannot reconcile those two things in every case. Something has to go. And the special advocate system, imperfect though it may be, is, it seems to me, the best available way of dealing with the small handful of these cases where the bulk of the evidence is simply not able to be cited in open court.
Robert, what happens if this bill passes and there is something goes wrong? How does this get corrected now? I mean, how do you know that it's gone wrong and how do you correct it?
Well, I think it depends on the cases that are brought. If we do see the trend continuing of cases being brought by people who are alleging misconduct by British government agencies and the sort of scenario where national security is an overwhelming part of the case, then I believe that rather than having quick settlements and out-of-court resolutions, we will see these cases being dealt with by judges, and we will find out in an open judgment what the liability or otherwise of the government is. And that surely is a good thing, because government needs to learn from its mistakes and its deliberate acts or omissions and to make good any wrong that it does to individuals. You know, as a democratic country, we must stand for values that can be respected internationally, and the issues of unlawful rendition and all the other concerns that a lot of us have in Parliament, I think deserve to be aired properly. And this is the great paradox about CMPs, this rather unattractive way of doing it, this way which doesn't sit comfortably with our principles of open justice, will somewhat ironically allow for a greater transparency and openness and accountability for decision making.
David, briefly, because we're coming to the end.
Yes, and you ask what happens if the wrong bill gets on the statute book. We've put in a word for Parliament. I'd just like to put in a word for the judges and for the legal system in this country, which have been able to improve previous laws in the counter-terrorism field. And I'd also, on a friendly note, like to put in a word for our wonderful NGOs, Reprieve being one example of those, who fight tirelessly to bring these cases to court and to expose what has been going on. And it seems to me that is vitally important.
Well, we're going to have to leave it there at that unusual moment of consensus, but do come back and join us on future editions of the Politics and Media programme.